This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Basic rule. You can alter the Constitution. Yes, you can. You can alter the Constitution. But you can only alter it if it's for the benefit of the members of the company, or the company as a whole. Who or what is the company as a whole? Who or what is the company as a whole? Let's say that we collectively are the entire membership of the company. We hold all the shares. There are no shares held by anybody else. The company as a whole clearly is represented by us collectively, the present shareholders. But it's also represented by the future, hypothetical, individual member of the future. We're talking about people who may own shares in this company in the year 2020, 2060, 2140. We're talking about the future individual hypothetical member. We don't know, they're probably not even born, they're probably your great-great-grandchildren. But they are potentially members of the company, and therefore any alteration must be for their benefit, as well as, clearly, our own benefit as being the present membership. So it's not just present membership, it's the future membership as well. The individual hypothetical member of the future, you can continue that second bullet point and say the individual hypothetical member of the future, on page 71, shall be equally likely to be benefited as be burdened by the alteration. A burden is a load or a responsibility. Shall be equally likely to be benefited as be burdened by the alteration. To burden or a burden. To burden is to load. You talk about donkeys, ezelis. Talk about donkeys being burdened and carrying a heavy load. Well, that's a donkey which is under a heavy burden. So a burden is a responsibility or weight or load. And the individual hypothetical member of the future shall be equally likely to be benefited as be burdened by the alteration. The illustration of Greenhouse and Ardern Cinemas involves three shareholders as in a cinema company, so it's in your films list. The three members of the company, we've got Greenhouse, who owns 2 shares, and we have 2 other shareholders, number 1 and number 2, and they hold 49% each. And the constitution of the company says that in the event that any member wishes to sell their shares, they must first of all offer them to the remaining shareholders at a price that they're prepared to accept. The Constitution clearly says that if Greenhouse wants to sell his shares, he must first of all offer them to these other 2. But equally, it applies to these other 2. If number 2 wants to sell his shares, he must first of all offer them to Greenhouse and number 1. These are called preemption rights. Preemption rights. And it gives me the first refusal. I am the first person, as number 1, as Greenhouse. I have the first opportunity to buy any of these shares that number 1 or number 2 wishes to sell. Me and the other person. An offer was addressed to these two 49ers. An offer was addressed to them asking if they wanted to sell their shares. We were going to take over the company, but we don't want Greenhouse. We're not interested in buying Greenhouse shares. We're interested only in these 49ers. And they said, well, we have to offer them first to Greenhouse. And the company, the buying company, worked out a way in which they could avoid these preemption rights. They were going to alter the Constitution so that would then say, in the event that a majority of the other shareholders agreed, then any shareholder could offer his shares to anyone he wants. And Greenhouse objected, because if you think about it, If the alteration goes through, it means that number 2 here, so long as the other shareholders agree by majority, well, it's a majority of 49 against 2. So this man can sell his shares to the new company. So we now have the new company as a new shareholder. And then number 1 says, I want to sell my shares. Do the majority of shareholders agree? And this one, with his 49, will beat Greenhalgh with his 2. So this one can sell his shares to the new company as well. And Greenhalgh objected. He said, I don't want to give up my preemption rights. This is not fair. And it went to court. And the court said, well, although it seems to be a bit unfair on you, it actually is for the benefit of the future hypothetical members, because it means that any member, so long as he has a majority acceptance, any member can offer his shares to anyone in the world. And this opens up an enormous market, 6 trillion people, or however many there are. It opens up an enormous market for looking for people to buy your shares in the future. And the court allowed the alteration to go through. It allowed it to go through. Even though it was not in Greenhalgh's personal interests, the individual hypothetical member of the future will be likely to be benefited. It's more easy to sell your shares. And the court accepted that that was for the benefit of the company. No outside contract. Carrying on, number 4 bullet. No outside contract shall prevent a change. But a company may become liable for breach of that contract. Southern Foundries and Sherlaw. Sherlaw was a director of Southern Foundries. There was an alteration to the articles which was proposed, the effect of which was to remove Sherlaw as a director. Now, Sherlaw can't rely upon being appointed as a director by the articles, but he did have a contract as a director in terms of if the articles are altered, Sherlaw then automatically will lose office. And that would be a breach of his directorial contract, his contract by conduct, or an oral contract. I have been providing the company with my services, and even though I may not have a separate written contract, I have been giving my services, the company has been receiving my services. Now by this alteration I am to be removed as a director, then surely you're in breach of my directorial contract. So the alteration, no outside contract as a director, shall prevent the change. But if you do change, you may find that you have an effect on that outside contract, and therefore you're liable for breach of contract. 5th bullet point. Even if a proposed alteration adversely affects only one member, even if it's targeted at an individual, that shouldn't prevent the alteration. This Greenhalgh wasn't targeted at Greenhalgh. It was simply to make it easy to transfer our 98% shares. But in the case Allen and Gold Reefs of West Africa, the constitution there was proposed to be altered. And the alteration was going to say that in the event that any member separately owes the company money, then the company will have a right of lien. A right of lien. You can remember lien. It's easy to remember. A right of lien, and I'll explain what it is in a moment. They would have a right of lien over that member's shares. And the effect of that is that that member is not able freely to deal or buy or sell any shares. He's not able to sell his shares because he owes the company money. And he was the only one. Allen was the only one who separately owed the company money. This alteration was specifically targeted at Allen. And he objected. He said, it's not fair. The majority are using their power to abuse me, to bully me. And the court said, well, yeah, maybe so. But let's think about the individual hypothetical member of the future. Let's think about the company's interests. If the company establishes a right of lien over the shares of a debtor, a receivable, surely that will make it easier for the company in the future to collect debts which are owed to it. And the court accepted and allowed the alteration to go through. Now, a lien is a possessory right. It's a possessory right. It means that, for instance, Christina here owes me money, and I have in my possession... Is this a phone? I have in my possession something belonging to Christina, and she owes me money. It's come into my possession by proper means. I've not stolen it. I've not cheated. It's in my possession, and I'm allowed to keep it until she pays me the money. And that's a possessory right. It means that I have possession. We have an expression in the UK, possession is 9/10 of the law. If I've got it and she owes me money, I can keep it until she pays me. So that's what a possessory right is. That's what a lien is. It's a strange word. I suggest that unless you're an accountant or a lawyer, you're not likely to know in the UK what a lien is. But it's an easy word to remember. Isn't it, Leanna? Yes. It's a very easy word to remember. Accountants have a very restricted right of lien. Where a client owes an accountant money, then the right of lien to keep hold of the client's records, keep hold of the documents and records that belong to the client, the accountant is able to keep those until the debt is paid, but there are restrictions on that possessory right of lien. So, for instance, the documents must have come into the accountant's possession by proper means. And the documents must be the documents of the client and not, for instance, the client's husband or the client's children or the client's friends. They must be the documents belonging to the client. Thirdly, the accountant must have done work on those documents in order that the debt shall be collectible and that the right of lien shall be capable of being exercised. The accountant must have done work on those documents, and the debt which is due is in respect of that work and not some earlier work. So it's very restricted is the accountant's right of lien. A solicitor, a sort of similar grade profession, a solicitor's got a much wider right of lien. They can keep any of the property of their clients in respect of any debt which their clients owe them. So we don't have to have documents on which we have done work in respect of which the debt is owed. If as a solicitor you have possession of any of your client's property, then you can keep it until the client pays you. And if you think that's an advantage when compared with accountants, think about the hotel owners. The hotel owners have a possessory right over all your possessions. Everything, your clothes, your suitcase, your laptop, anything that they have in their possession in respect of anything that you owe, they can keep it. And there's one exception to what they can keep. They can keep all your clothes, which is going to be interesting as you leave the hotel. The only thing that they can't keep is your horse. If you've ridden to the hotel on your horse and it's in the hotel stables, they're not allowed to keep your horse. It's a little bit of history. It goes back, obviously, into the 18th, 19th century. But you're allowed to ride away naked on your horse. Alterations, I'm halfway down, page 71. Alterations allowing compulsory purchase of a minority's share will normally be disallowed. You should not be able compulsorily to buy out a minority who you no longer like. So again, the entire lot of us are shareholders, and Sandra's been upsetting a number of people just recently. I want Sandra out, and we probably all agree that Sandra should leave us. So let's alter the articles that say, if we have a shareholder called Sandra, we shall buy out her shares. Or any alteration, the effect of which is to compulsorily make Sandra sell her shares. Not normally allowed. The courts will see that as an abuse of power, and it's unfair on the small shareholder, the one who owns only a few shares. And the case is Daff and Tinplate. Daffen template, and the next word after the V, the next word is a town in South Wales, the pronunciation of which is not Llanelli. The pronunciation is Llanelli. So when the Welsh have a double L in their words, it comes from the back of the throat. Llanelli. So Llanelli Steel. Daffen template Llanelli Steel. Llanelli Steel was a consortium company. And the shares of this consortium company were owned by a number of steel mills, of which Daffen template was one. And Daffen owned 8%. And the idea of setting up this joint company was that all these separate steel mills would put their business through this central company, and as a result they would enjoy the benefits of economies of scale and restructuring, and Llanelli Steel would then make profits, and at the end of the year they would distribute the profits according to the shareholders. But Daffen decided they no longer wanted to use Llanelli Steel. They were going to use a different steel company called Binia, or Binia, the Binia Steel Company. And they started putting their business over to Binia. And of course the other shareholders found out. So they proposed an alteration to the articles that said, in the event that 90% agree, then they should have the ability to buy out the remaining less than 10%. That's clearly a very sensible alteration in the context of Daffen template, because Daffen was breaking the rules. He'd moved away and taken his business to Binia. But he objected. Daffen template went to court and said, this is not fair. They're targeting it at me. And the court said, well, according to Allen and Goldreef's, that it's in itself does not prevent an alteration. But what is potentially offensive is that maybe later, Christina, who has done nothing wrong, suddenly finds that 91% of the shareholders who are left are knocking on her door saying, we're going to buy your shares and there's nothing you can do about it. So any future less than 10% shareholder is suddenly faced with having to sell their shares for no apparent reason. And the court wouldn't allow the alteration to go through. The individual hypothetical member of the future would likely be quite unfairly damaged by this alteration, which in this context of Daffen seems to be quite a fair alteration, quite reasonable. But in the context of the future, unknown, hypothetical member, it's not fair. Potentially it's not fair. So the court would not allow that alteration to go through. An alteration allowing the expulsion of a defrauding director, that's okay. If you find a director who is defrauding the company, then you can get rid of him. You can alter the articles to have the effect that you will remove this director. That's the case Shuttleworth and Cox. And an alteration allowing the expulsion of a competing member. This is Sidebottom and Kershaw-Lees. And I think I'm right in saying that if Sidebottom's situation arose now, that we have a competing member, a member of our company is in direct competition with us, it's not likely that the court would allow that alteration. It's not likely they would allow it. This is an early 1900s case, so it's about 100 years ago. And I presume at the time 100 years ago, I don't know because obviously I'm not that old, but I could ask John. I presume that in those days, if you were a member of a company, you were able to get information about the company which was not generally available. But nowadays that's not right. Surely in these days of openness and transparency and full disclosure in financial statements, I don't think there's anything about any of your companies that you hold shares in. I don't think there's anything there any information that you could get which is not generally available. I'm not talking about your employer companies, I'm talking about companies in which you have an investment. So on the basis that openness and transparency and fairness and accountability and disclosure, on the basis that we have all these now in the early part of the 21st century, I don't think that Sidebottom Kershaw lease would be found the same. So a competing member, according to historic case law, then it's acceptable to alter the articles to get rid of a competing member. But it's got to be up in the air. There's got to be an element of doubt in the year 2011. It's possible to prevent alteration in two ways. I've only given you one alteration here, but it's possible to prevent it in two ways. The first one is weighted voting rights. And weighted voting rights, in the case Borschel and Faith, operated in this way. A man, a father, has got 3 children. He sets up a company, and he leaves the shares to his 3 children, 100 shares each. Older sister, so sister number 1, sister number 2, and little brother. And the Constitution said these 3 were directors, the only shareholders. And the Constitution said that in the event that any director is proposed to be removed, then that director's shares shall carry 3 times their normal voting power for the purposes of the resolution of removing the director. And the 2 older sisters got together and said, let's get rid of little brother. Let's vote him off the board. And the resolution, the vote came. Those in favour, 100, 200. Those against, 300. So by applying weighted voting rights, you're putting individuals into the position where they can prevent an alteration. It is available. And another way, which is not in your notes, another way of preventing an alteration is that you can put within the Constitution that if there is a resolution which has a direct effect on an individual member, that resolution cannot be discussed and voted upon unless that member is present at the meeting. So if there's a proposed resolution to remove Benita, then we can't discuss this removal of Benita unless she is present at the meeting. So she can prevent the alteration simply by staying away. So different ways in which you can prevent alterations, but normally the general principle will apply that an alteration is allowable if it is for the benefit of the company as a whole.